Tariffs are illegal. A federal court just struck down President Trump's quote-unquote Liberation Day tariff orders on the grounds that screaming quote-unquote emergency is not a cheat code that allows him to act without congressional approval. The ruling deals another blow to Trump's signature strategy of running around like Chicken Little, declaring everything he doesn't like is an emergency existential threat to America. And by now you've probably seen this pattern. Foreign gang members in the US? Emergency. Mining companies can't drill in federal land? Emergency. A grad student led a protest at Columbia University? You better believe that's an emergency. Truly, so far, there is no issue too small for Trump to declare that the sky is falling. But in particular, President Trump's favorite way of dealing with emergencies is tariffs. He loves tariffs so much, he dubs himself Tariff Man.
I think the tariffs are going to be the greatest thing we've ever done as a country.
And as we talked about at length in our entire video talking about the dubious nature of these tariffs, although the Constitution gives Congress the power to levy tariffs, President Trump has argued that his tariffs are justified by the International Emergency Economic Powers Act, known as IEEPA, which does give the president some authority to regulate international commerce in response to unusual or extraordinary foreign threats. But as we talked about, a group of small companies sued Trump, alleging that his tariffs would probably put them out of business. They allege that the tariffs exceeded the president's authority under IEEPA and violate the Constitution. And the U.S. Court for International Trade just agreed with them. So today we're going to talk about the Court of International Trade, what they ruled and what happens next. Now, the U.S. Court of International Trade is a specialized federal court based in New York City with jurisdiction over cases involving international trade and customs laws. And in fact, they have exclusive jurisdiction over tariffs. And like other federal district courts, the CIT is established under Article 3 of the Constitution, meaning its judges are appointed by the president and confirmed by the Senate. The court primarily hears civil actions arising from U.S. customs and trade statutes, such as disputes over tariffs, customs classifications, and trade remedy laws. Its decisions have the force of law and can be appealed to the Court of Appeals for the Federal Circuit and eventually the Supreme Court, much like how district court decisions go to the regional circuit courts of appeal. But unlike federal district courts, the CIT has nationwide jurisdiction and can also hold hearings in foreign countries. At the moment, 9 judges serve on the CIT. Under 28 U.S.C. 251, quote, no more than 5 of such judges shall be from the same political party, and most cases are decided by a single judge. However, if litigants challenge the constitutionality of a law or the applicability of an executive order, the case will be decided by a 3-judge panel, which is what happened in this particular case. So let's talk about this particular case. As you probably remember, in early 2025, President Trump issued a series of executive orders under IEEPA declaring national emergencies related to drug trafficking and border security. These declarations targeted cartels and foreign governments, including Mexico, Canada, and China, for allegedly failing to stop the flow of fentanyl, other drugs, and criminal activity into the U.S. And the president purported to impose a series of trafficking tariffs, 25% duties on most goods from Mexico and Canada, and 10% on Chinese goods, later raised to 20%. These actions were accompanied by shifting deadlines, partial pauses, and selective exemptions, such as lower duties on Canadian energy and potash. Then in April of 2025, Trump announced a new set of, quote, worldwide and retaliatory tariffs, which were mostly worldwide and were not retaliatory, but he was again invoking IEEPA. These included a 10% tariff on all imports from all countries, with higher country-specific duties up to 50% on 57 nations. Trump justified the worldwide tariffs on the dubious basis that trade deficits were national security threats. And eventually, in response to retaliation from China, which was retaliation for the retaliatory tariffs, Trump increased duties on Chinese goods up to 125% before later reducing them back down to 10% temporarily. So throughout February and May of 2025, the tariff landscape shifted frequently, with multiple executive orders adjusting rates and timing. Now, Trump paused implementation for some countries and product categories, granted temporary exemptions, and altered the scope of the tariffs based on political and diplomatic developments. And I'll tell you, it's been real interesting owning a business during all these machinations. But despite some rollbacks, most of the trafficking and retaliatory tariffs remained in effect, with Chinese goods facing a combined tariff burden of at least 30%. So yeah, during this time, America's tariff policies depended entirely on the president's personal whims, which could and did change daily. Which was odd because the Constitution didn't give the president any of this kind of power. It gives Congress exclusive powers to, quote, lay and collect taxes, duties, imposts, and excises, and to regulate commerce with foreign nations. This is a bedrock principle of constitutional law, but President Trump tried to wield IEEPA as that one weird trick that allowed him to bypass Congress. Which was interesting because legal commentators talked about how radical the imposition of these tariffs were and how legally dubious the footing was for the tariffs, whereas the mainstream media just sort of took the president at his word that he could do all of this stuff. Now, if you imposed illegal tariffs and caused billions of dollars of damages, you'll probably want a good lawyer. But if you want a great lawyer, let my law firm, the Eagle Team, help. If you've gotten in a car crash, suffered a data breach, especially if you got one of those data breach letters saying your information might have been leaked, or dealing with a workers' comp or social security issue, we can represent you or help find you the right attorney. By the way, we don't get paid unless you do, so there's nothing up front. So just click on the link in the description or call the phone number on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team.
You wouldn't eat something without knowing what's in it. That's why nutrition labels exist. That's the idea behind the political bias and factuality labels you see on ground news. Nearly every news source on ground news
Team. But that's why a small group of businesses in several states filed suit against the Trump administration. Quote, the businesses that bring the VOS Action, VOS Selections, Genova Pipe, Microkits, Fish USA, and Terry Cycling allege and aver that they have suffered and will continue to suffer economic injuries as a result of the worldwide and retaliatory tariffs. VOS alleges that the worldwide and retaliatory tariffs have occasioned difficulties with sourcing and pricing, and also that the reduction in cash flow caused by increased tariffs also necessarily reduces the company's inventory, leading to an overall reduction in purchase orders placed with both foreign and domestic suppliers. Its CEO says, quote, tariffs must be paid by VOS upon arrival at the Port of New York, putting a large immediate strain on its cash flow. Genova Pipe alleges, quote, the tariffs will directly increase the cost of raw materials, manufacturing equipment, and resale goods imported from abroad. The other plaintiffs state the high tariff rates will mean they cannot order supplies from China. For Microkits, this may mean, quote, it will likely be unable to pay its employees, will lose money, and as a result may go out of business. Now, President Trump tried to get the case dismissed by claiming that since he's paused collection of the tariffs, the plaintiffs lack standing because they haven't had to pay the tariffs yet. And during President Trump's public appearances, he always claims falsely that tariffs will be paid by foreign governments and that they will not hurt American businesses. Though notably, he dropped that pretense in court and admitted that yes, tariffs are taxes paid by businesses. Yes, of course they are. That's what Liz Dye and I have been explaining. Tariffs are taxes on imported goods, including parts and supplies, which are paid by the importing companies and are often, if not most of the time, passed on to consumers. But the plaintiffs contend that Trump exceeded his statutory authority by using IEEPA to impose tariffs on imports from nearly every country in the world. In response, the Trump administration argued that very scary people like international drug cartels, human traffickers, and foreign governments with economic policies Trump doesn't like are trying to undermine America, which apparently qualified as an emergency. The administration argued that Trump was allowed to impose tariffs as part of a broader strategy to combat these dire transnational threats. For example, the trafficking tariffs targeting Mexico, Canada, and China were supposedly necessary to combat those countries' failures to curb the trafficking of fentanyl and other drugs into the US. Similarly, the worldwide and retaliatory tariffs were framed as a response to a long-term trade imbalance and unfair foreign trade practices, which the president claimed endangered US national security. But the three-judge panel heard the case and ruled for the plaintiffs on summary judgment. Summary judgment is a decision made by a court when there is no genuine dispute about the key facts of a case, meaning that the case is solely about the interpretation of the law with the given facts that are presented. And here, the three-judge panel included Judge Timothy Reif, who was nominated by President Trump, Judge Jane Rustani, who was nominated by former President Ronald Reagan, and Judge Gary Katzman, who was nominated by former President Barack Obama. And the court said, well, IEEPA allows the president to regulate importation of any property in which any foreign country or a national thereof has any interest by any person in response to an unusual and extraordinary threat, it does not grant him blanket authority to impose tariffs on any country for any reason at any rate. The judiciary has developed two doctrines to ensure the branches of government do not give away their powers to each other. The non-delegation doctrine says Congress cannot give away its core legislative powers, especially the power to make laws, to another branch of government without clear limits or guidance. Now, Congress has been extraordinarily weak about protecting its own powers during the Trump presidency, but that doesn't mean that Congress can just delegate its legislative powers to the president or that the Constitution is inoperable because of congressional inaction. Quote, the Constitution provides that all legislative powers herein granted shall be vested in a Congress of the United States. Congress is empowered to make all laws which shall be necessary and proper for carrying into execution its general powers. The Constitution thus establishes a separation of powers between the legislative and executive branches that the framers viewed as essential to the preservation of individual liberty. To maintain this separation of powers, the Congress manifestly is not permitted to abdicate or to transfer to others the essential legislative functions with which it is thus vested. So that's basically the non-delegation doctrine. Additionally, the major questions doctrine says that a court should not assume Congress gave the executive branch broad authority to decide economically or politically significant issues unless Congress clearly said so. And what's interesting about this decision is that the court is using those doctrines doctrines as a guidepost but not clearly invoking them, and instead used normal canons of construction to interpret the statutes as given. The panel found that using IEEPA to impose worldwide tariffs of up to 50% was a decision of major economic and political significance, and since IEEPA did not clearly grant the president that level of authority interpreting the statute, the court refused to read that power into the statute. Now, President Trump argued that his use of IEEPA was consistent with the way other presidents have used analogous powers. For example, in 1971, President Nixon imposed a temporary 10% tariff on all imports under the Trading with the Enemy Act, the TWEA, citing a national emergency. TWEA, quote, authorized the president during an emergency to exercise the delegated substantive power, i.e. to regulate importation, by imposing an import duty, surcharge, or by other means appropriately and reasonably related to the particular nature of the emergency declared. And in that case, courts upheld Nixon's action only because it was temporary and clearly tied to a specific economic emergency, a balance of payment crisis. The tariffs were narrow in scope and duration and were consistent with congressional intent. However, even then, Congress still thought the president had been given too many emergency powers, so 3 years later it limited the president's power under the TWA to wartime. It then passed IEEPA to largely replace TWEA, and the congressional record showed that Congress intended for IEEPA to, quote, confer upon the president a new set of authorities for use in time of national emergency, which are both more limited in scope than those of TWEA and subject to more procedural limitations, including those in the National Emergencies Act. So the takeaway was that Congress limited TWA to wartime and gave the president narrower powers to impose tariffs under IEEPA. But the Trump administration interpreted those events backwards, asserting that IEEPA gave the president the power to impose unlimited tariffs in response to trade-related emergencies that are actually broader than TWEA, which again was limited to war. But that's where statutory construction comes in. In drafting IEEPA, Congress did not intend to confer more power on the president than he had under TWA, and courts will bend over backwards to interpret statutes in such a way that would prevent them from being rendered meaningless. To do so would contradict a basic canon of statutory construction that every law must be read to have a real and distinct meaning, not to nullify other carefully crafted legislation. But President Trump has repeatedly cited the trade deficit as a looming national emergency justifying the tariffs. Now, a trade deficit occurs when a country's imports exceed its exports, meaning that more goods and services are brought into the country and purchased than are exported and purchased by other foreign countries. A trade deficit doesn't necessarily mean a country is being ripped off by its trading partners, as President Trump has claimed over and over again. In most cases, it just means that the US buys more products from a given country than that country buys from the US, which can be a great sign of a very strong economy. And as plaintiffs pointed out in this case, the US has run a trade deficit with the rest of the world for 49 consecutive years. And besides, there is a law that deals explicitly with trade deficits. Section 122 of the Trade Act of 1974 gives the president specific limited authority to act in response to balance of payments deficits. Under Section 122, the president may impose tariffs or quotas of no more than 15% for a period not exceeding 150 days. The statute was also enacted to constrain executive action in this area following President Nixon's broad use of tariff powers. But the Trump administration argued that IEEPA could be used instead of or in addition to Section 122, effectively allowing the president to impose unlimited tariffs in response to an emergency caused by persistent trade deficits, and that, of course, trade deficits constitute an emergency in the first place. But the court flatly rejected this argument. When Congress has spoken directly to a specific issue like trade deficits, it's generally improper to interpret another statute in a way that would override or nullify those carefully crafted limits. In other words, if IEEPA were interpreted to allow the president to impose far more aggressive and open-ended tariffs than Section 122 permits, then Section 122 would be rendered meaningless. Instead, the two statutes must be read together in a way that preserves their distinct roles. And Section 122 addresses economic imbalances like trade deficits with clear constraints, while IEEPA is meant for genuine emergencies of foreign origin. And because Trump's tariffs far exceeded the limits of Section 122 and were based on concerns Congress already legislated on, the court held that the use of IEEPA in this context was unauthorized and unlawful. So, TLDR, IEEPA is still not a cheat code for rewriting trade policy. So, as the court said here, underlying the issues in this case is the notion that the powers properly belonging to one of the departments ought not to be directly and completely administered by either of the other departments. Citing Federalist Number 48. Because of the Constitution's express allocation of the tariff power to Congress, see the U.S. Constitution, we do not read IEEPA to delegate an unbounded tariff authority to the president. We instead read IEEPA's provisions to impose meaningful limits on any such authority confers. Two are relevant here. First, Section 1702's delegation of power to regulate importation, read in light of its legislative history and Congress's enactment of more narrow, non-emergency legislation, at the very least does not authorize the president to impose unbounded tariffs. The worldwide and retaliatory tariffs lack any identifiable limits and thus fall outside the scope of Section 1702. Second, IEEPA's limited authorities may be exercised only to deal with an unusual and extraordinary threat with respect to which a national emergency has been declared and may not be exercised for any other purpose. As the trafficking tariffs do not meet that condition, they fall outside the scope of Section 1701. Or as legal commentator Matt Levine at Bloomberg helpfully summarized, there are two possibilities here. One, the IEEPA doesn't actually give the president the power to impose tariffs on every country just because he doesn't like free trade. IEEPA powers are only for emergencies and international trade exists, can't be an unusual and extraordinary threat to the US. And two, if the IEEPA did give the president sweeping powers to impose tariffs, that would be unconstitutional. But let's focus on that last part. What about the trafficking tariffs targeting Mexico, Canada, and China on the basis of an emergency involving illicit drugs? Well, let's look at the text of IEEPA. 5 U.S.C. Section 1701 states, quote, "Any authority granted to the president by Section 1702 of this title may be exercised to deal with any unusual and extraordinary threat, which has its source in whole or in substantial part outside the United States, to the national security, foreign policy, or economy of the United States if the president declares a national emergency with respect to such threat." And the next provision of the law says, quote, "The authorities granted to the president by Section 1702 this title may only be exercised to deal with an unusual and extraordinary threat with respect to which a national emergency has been declared for purposes of this chapter and may not be exercised for any other purpose." And the court found that, quote, "This provision limits the president's exercise of IEEPA powers to a limited set of situations. Under it, IEEPA powers are available only where all the following conditions pertain. First, there must be a threat which has its source in whole or substantial part outside the United States to the national security, foreign policy, or economy of the United States. Second, this threat must be unusual and extraordinary. Third, a national emergency must be declared with respect to that threat. And fourth, the president's exercise of IEEPA authority must deal with the threat." Now, President Trump argued that he could meet that standard because essentially there is an emergency when he says there is. This is the same argument that the administration is making to invoke the Alien Enemies Act in cases involving deportation of alleged members of the Venezuelan gang Tren de Aragua. But Trump also asserted that his emergency declaration is a political question involving foreign affairs, which is traditionally beyond the purview of the courts. In other words, the courts lack the ability and authority to pass judgment on whether there is or is not a national emergency. But the judges were unconvinced. They held with respect to some of the language that, quote, "This reliance on the political question doctrine is misplaced. One of the judiciary's roles is to interpret statutes even when the decision has, quote, significant political overtones. And trade policy is a subset of foreign policy, but the courts aren't required to, quote, unthinkingly defer to the executive." And the court held that Trump's opinion does not necessarily have the force of law. Quote, "IEEPA requires more than just the fact of a presidential finding or declaration. The authorities granted to the president by Section 1702 of this title may only be exercised to deal with an unusual and extraordinary threat with respect to which a national emergency has been declared for purposes of this chapter and may not be exercised for any other purpose." And the court found that specifically, this language does not commit the question of whether IEEPA authority deals with an unusual and extraordinary threat to the president's judgment. So it does not grant IEEPA authority to the president simply when he finds or determines that an unusual and extraordinary threat exists.
It starts small, doing what you can when you can. It's just one
Or determines that an unusual and extraordinary threat exists. But let's assume for the sake of this case that international drug trafficking is a national emergency. Does that mean the US can use trade policy to deal with international drug cartels? In Trump's view, yes, he has the right to take any action that would put pressure on the governments where the drug cartels operate. But the court didn't buy that argument because Trump's tariffs do not actually address the threat of drug trafficking themselves. Surely this is not what Congress meant when it clarified that IEEPA powers may not be exercised for any other purpose than to deal with a threat. So the court ruled that Section 1701 doesn't allow the delegation of emergency powers unless, quote, "the action taken bears a reasonable relation to the emergency giving rise to the action, and that the nature of the emergency restricts the how of its doing, i.e. the means of execution." The government's concept of leverage would sap those words of their meaning if leverage were all it took to establish a reasonable relation between these means and the particular emergency of trafficking. Yoshida 2's means-end test would be trivially easy to pass. The Yoshida reference here refers to the Nixon-era tariff case that established precedent in this area. But here the court vacated the Trump tariff orders and permanently enjoined their enforcement. So what happens now? Well, the Trump administration immediately filed a notice of appeal, and the Federal Circuit issued an administrative stay pausing the enforcement of the CIT's ruling. Now, an administrative stay is not a long-term stay. What it means is that the contested tariffs will remain in effect only while the appeals court reviews the government's motion for a long-term stay pending the appeal. The plaintiffs have to submit their response by June 5th, and the government must reply by June 9th, so the turnaround on this briefing is going to be very quick. The Federal Court of Appeals will then decide whether to implement a real stay pending the entire appeal, which might be the whole ballgame because an appeal can take a long time. And then, of course, it might go to the Supreme Court, but here it's not clear that the Supreme Court would want to take this one up and might not grant certiorari and just leave the decision of the Court of Appeals in place. Though Trump has not taken this latest setback well, he posted that, quote, "Nothing can stop what is coming, and he is on a mission from God." So while he's stopping just short of declaring himself God, the president indicated that apparently God loves tariffs. And once again, Trump is telegraphing that he might not be stopped by the judiciary here. Here, in response to the courts invalidating Trump's executive order, the stock markets just didn't even notice, it seems. Which probably indicates that people are not taking these tariffs seriously anymore. But it's particularly interesting to see how the media is covering this. Immediately after the court ruled against the Trump administration, over 350 sources covered it, with about 30% of the sources coming from the left, 45% from the center, and only 25% coming from the right. And when you examine the headlines, you see some very different frames emerge that shape how readers interpret and understand the events that are unfolding. The left emphasized the story as a victory against Trump personally, commonly using language humiliated or placing emphasis on the outrage expressed by people in Trump's inner circle. Center sources typically quoted the court's finding that the tariffs are illegal and that the president exceeded his powers, while sources on the right were most likely to refer to the Federal Court of International Trade as a New York-based court, implying a geographic political bias in the ruling. Now, the headlines you read first have immense power to shape how you understand the news, and it's why I like to get the news from as many angles as I can, which I do with the help of today's sponsor, Ground News. Ground News is a website and app developed by a former NASA engineer on a mission to give readers an easy, data-driven, objective way to read the news. And right now they're offering Legal Eagle viewers 40% off their unlimited access Vantage subscription. You can scan the QR code or use the link in the description to get a discount for a limited time. Or simply download the Ground News mobile app and enter Legal Eagle, all one word, as the discount code. Because Ground News gathers related articles from around the world and across the political spectrum, so you can see the bias and compare coverage. Every story comes with a quick visual breakdown of the political bias, factuality, and ownership of the source's reporting, all backed by ratings from 3 independent news monitoring organizations. Now, one of my favorite parts is their bias comparison feature, which highlights specific differences in reporting across the political spectrum. This can be especially helpful when reading stories from sources you've never heard of, where there's no telling who owns it or what agenda they might have. I also love their blind spot feature, which shows you stories that are underreported by either side of the political spectrum. Like this related story about how Trump's tariffs led to a